Can your parents write you out of their will? Hi, my name is Alec Osland, and I'm an attorney at the Yanowitz Law Firm, where we've been assisting Minnesota families with wills, trusts, and probate for over 3 decades. Did your parents tell you that they wrote their will and they left you out of it? And now you're wondering, is this even legal? Well, the short answer is yes, this is legal. You are not entitled to inherit anything from your parents, and your parents can pick where their money and assets go upon their death. There are a few exceptions to this rule. For example, if a spouse completely disinherits the other surviving spouse and there's no prenuptial agreement, then that surviving spouse may claim a marital elective share for part of the estate. So, okay, spouses are protected. What about children? Parents can completely disinherit their children, provided, however, that parents cannot completely disinherit their minor dependent children. So again, you as the child, you have no right to inherit your parents' money. It is your parents' money, and they get to pick where it goes. It's not yours. The big takeaway with this is, as long as a person is not under duress, they don't have any capacity issues, then that individual gets to pick where their money and their assets go upon their death. I brought up two things there. As long as they have capacity and they're not under duress. Why did I bring that up? Well, there can be certain claims to challenge the validity of that will. If a parent did not have capacity when they executed that will, someone can bring a claim of lack of capacity to challenge whether that will is going to be valid or not. For that to work, the person must prove that the parent did not have the capacity to execute their will and therefore it should be, invalidated. They would most likely rely on medical records that would help establish that the parent did not have the legal capacity to make the estate planning decisions that they did. Another challenge that they could bring is one of undue influence. In Minnesota, undue influence refers to situations where someone, maybe due to manipulation or pressure, they create an estate planning document that they normally would have not made. Someone is making mom or dad draft their documents in a way that they normally would not have. So an action can be brought there to also invalidate the will. Now, all of this being said, if you are a parent and you are wanting to disinherit a child, it is very, very, very important that you work with an estate planning attorney who can help protect you and your estate plan so that your goals are accomplished. When we meet with clients, we gauge their capacity and we document everything. And if someone does not have capacity, then we're not going to work with them. So by working with an estate planning attorney, you're going to have witnesses that if there is a question on your capacity, these witnesses and the attorney, they can testify that yes, you did have capacity when you made these decisions and you knew exactly what you were doing. Further, there's going to be witnesses that can help confirm that, you knew what you wanted to do and no one was forcing you to do this, that, this was completely your decision, which in turn, again, this protects the estate planning documents so that they can accomplish the goals that you want. So, if you're interested in learning more about estate planning, make sure you subscribe to our channel to find out when we post another video. Thanks. Have a great day.